Well, good morning, everyone. Thomas Montgomery here. We get together with our distribution partners on a daily basis, most weekdays at 8 o'clock Central, to talk about strategies, tips, techniques, share success stories, and support each of you. We typically will record these and post them up on our YouTube channel, so you can go back and reflect on any that you've missed or revisit those that you maybe want to do so. Today is Monday, May 22nd, 2023, and we're going to be talking today about a more advanced strategy. So let's step back and look at the big picture. What is it that you and I do? You and I are technical advisors, and we help small businesses qualify for funding. There are millions, literally, of small businesses, plus many entrepreneurs that are pre-formation. So there's nearly an infinite supply of small business owners that want or need capital. But what do you and I know? It's not just wanting or needing it. We must qualify for it. And so what you and I do is help them credibly, legitimately, of course, legally qualify for funding. Guarantee that. They pay nothing up front for the access to capital. We work with them. We guarantee them a minimum of $100,000 in writing. Now, when we talk about qualifying for funding, it comes back to just like you and I learned in school about the 3 C's. Remember when you learned that? Credit, collateral, and capacity. Those are the things that typically lenders will look for in determining if there's going to be an approval and how much of an approval. Well, one of those C's is collateral. What is collateral? Collateral are the assets that we can objectively illustrate on our financials that can be committed for the lender in case we fail to repay. So that's what collateral is, right? When you buy a house, the mortgage company puts a lien on the house. If you don't pay the house payments, they'll foreclose on the house. When you buy a car and you finance it, there's a lien on the car. If you don't pay your car payments, they'll come repossess it. So for business funding, it's not unusual for lenders to also want to mitigate or limit their risk by having collateral. So what we know is a lot of small business owners don't have enough collateral. So the amount of money that they want to borrow exceeds the collateral that they have. We call that a collateral shortfall. It's not a mystery. It's not gray. It's not smoke and mirrors. It's just a mathematical formula, right? Okay, you want to borrow $100,000. Let's look at your balance sheet. Do we have collateral to pledge? If not, no worries. We will provide collateral for clients. Legally and ethically, we will transfer assets from our books over to the clients, and then they will have the collateral on paper to qualify. Well, when we're transferring collateral, what we're actually transferring is not pie in the sky, not anything that's abstract, but receivables. And what is a receivable? A receivable is an asset that is reflective of money owed to the business. So when we're transferring receivables to the client, we help them put them on the balance sheet. So now they have collateral to qualify for funding. But we don't want to just stop with that. And that's a huge goal and problem resolved in itself, resolving the collateral shortfall. But we want to take that a step further and then help them liquidate those receivables to turn into cash. Because again, everything we do needs to be documented, it must be legal, must be compliant. So when we say, as the screen shows here, that we're going to transfer receivables over, these are real, missed the R there, didn't I? These are real receivables. So today we're going to talk just for a few minutes about some best practices of how to collect money that's owed. So let's go through it, and we're going to go through 3 steps. So are we asking you to go do this? No. Are we saying that the client has to go figure this out and do it? No. We'll actually take care of it for them if they would like. But our goal today is to help you become more educated, more familiar, more literate with the process, some best practices, in fact, of collecting receivables. Okay? So the first step when you have money owed to a business is to invoice the debtor, right? So we have the creditor, the money, who the money is owed to, and the debtor who owes the money. And this can be as simple as you have your yard cut. So the lawn guy or lawn gal sends you an invoice. Say, hey, I've cut your grass 4 times this month, 50 times a week. You owe me $200. So in that case, if it was your yard that was cut, you're the creditor, and the lawn guy or gal is the debtor, right? So it's not bad to have invoices. Many businesses have invoices. So if money is owed, clearly step one is that we would want to invoice the debtor to let them know, hey, you owe, here's how much, here's why. And if they have a question about it, if they want to doubt the legitimacy of it, then they let us know that so we can resolve it, because obviously we're not going to invoice anyone for anything that's not owed. It's not documented. It's not contractual. Well, how do we invoice them? Well, most small business owners are sophisticated enough to know how to do an invoice and probably have invoiced before. But regardless, we typically recommend using a software like QuickBooks. QuickBooks is the world's most widely used small business accounting software. We don't have any financial interest. I used to be a high school teacher. You all know that. And QuickBooks was actually one of the classes I taught to high school students. Isn't it crazy? Kids graduate from high school now often with more knowledge than what many to most entrepreneurs have that are out running small businesses. Bizarre. But anyway, so QuickBooks is a great way to invoice people that owe you money. And then by using QuickBooks, we can even factor it. Now, what does factoring invoices mean? That means that the debtor owes the money. Let's say the debtor owes $1,000. Just use a round even number. So $1,000 is owed by the debtor to the creditor. And so even before the debtor pays, the creditor can get an advance. And this is not merchant cash advance, so don't confuse it with that. But you can get factored. You can get the money before even the client pays. And so that's one of the reasons we like using QuickBooks, is because then we might be able to factor those receivables. Now, when we factor receivables, they do not forward 100 cents on the dollar. We'd love that. That'd be great. But in fact, through QuickBooks, we can get 97 cents on the dollar, which isn't bad. So in that case of the $1,000 owed, we wouldn't get $1,000 next day or within 2 days. We'd get $970 because the factoring company wants to charge a fee. So there's step one. Nothing too innovative about that, but we need to start with that mindset. So again, why is this relevant? You and I are technical advisors. We help small businesses qualify for funding. How do you qualify? The 3 C's. One of the 3 C's is collateral. Well, most small businesses, or at least many, have a collateral shortfall. So can you and I fix it? Absolutely, we can fix it. We can literally transfer receivables to them. So now it's fixed. Now they have the collateral. But we don't want to just stop there. We also want to help them liquidate the receivables. And so that's what we're going through, our 3 steps to liquidate receivables. Now, with that being said, guess what? Some people will pay bills, if they actually owe it, of course, they're legitimate, after you invoice them. So that makes a lot of sense. That's great for bringing money in. Now, will everyone pay it? Probably not. So then we need to have a next step, a way to escalate our collection efforts when people don't pay as contracted. Therefore, there are different ways to do that. One of which, one of my favorites, is to litigate. Sounds negative. You know, somehow in our society, litigation means hateful or aggressive, but it's not. So there's 2 parties, again, the creditor and the debtor. The debtor owes the creditor money. The debtor hasn't paid. And so in our society, we have a legal system that allows the creditor to sue the debtor for the amount owed. Now, if anyone is negative, it's the debtor. The debtor should have paid their bill, right? The debtor didn't do what they promised to do. If they would have, then we would have been able to stop with step one. And that's what we hope most people will pay as agreed. But if they don't, then we can litigate. We can do this for our participants that are getting receivables from us, which I mentioned before. We have two different ways of transferring receivables to our clients to resolve a collateral shortfall. We have the quick cash program, which is receivables in $10,000 increments for portfolios, and then the full collateral support program, which is $100,000 of receivables. Now, you might say, well, wait, why would I want these receivables? Well, if a small business wants to borrow money, but they don't have enough collateral, true collateral demonstrated on their financials, they have a collateral shortfall, so we can fix that by transferring real receivables over. That allows them to qualify for funding, but we don't want to stop there. We don't want to just stop with the funding. We want to help them liquidate the receivables because they're real. And so when we transfer receivables, it's either through quick cash, which is 10,000 portfolio, as I mentioned, or collateral support program, essentially the same as quick cash, but in $100,000 increments. Now, when it comes to litigation, this is where things get more complicated, because the truth is any one of us, me, you, we've got 215 of you on the Zoom today. Any of us could go sue someone else. Now, again, that sounds like negative or mean or vindictive. No. What we're doing is we're trying to resolve the fact that the debtor owes the creditor money. The debtor hasn't paid as they promised. And so in our society, we have a legal system to resolve that. So anyone can litigate on their own behalf, or you can hire an attorney or a litigation firm to litigate for you. Here's what I found out, that the way that the petition, which I'll define in a moment, is filed makes a tremendous difference. Okay, so what is a petition? A petition is the essentially the paperwork to file the suit. So it's the paperwork submitted to the court saying here's who the creditor is, here's who the debtor is, here's how much they owe, here's why, and I want to sue them. So the petition is what goes into the court, and then the court creates what's called a citation, and then the citation is sent to the debtor to notify them that they're being sued. My point is that there's not just one way to go about suing people. And so we found tremendously different, well, more success in more advanced ways than basic ways. But the truth is, in our legal system, anyone can sue someone else. You don't have to be an attorney to sue the debtor. So if you want, we can do that for you. We'll handle the litigation, subpoenas, and examining witnesses is an important part of that. Okay, so now what we want to do, well, let me wrap up step 2, and then we'll get into step 3, which is really the meat of the matter today. We want to invoice people that owe us money. We want them to pay as agreed. If they don't, we can escalate that. One way to escalate it is to litigate. Litigating breach of contract lawsuits is pretty straightforward, and typically it's going to be pretty much 100% success. Very rare. Could happen, but very rare that you lose. In other words, if someone owes you money, you sue them, you get the documentation, almost always going to win. Almost always going to win. Now, I know in our circumstance, if we don't win, then I'll say this respectfully, we attack the court. Then we threaten to sue the court for illegally interpreting the agreement, and we put the court on notice. So even if you do lose once in a while, we're not talking about appeals, you don't need to appeal. There are ways to motion for reconsideration that that could even allege judicial misconduct by the court. They don't want to get in trouble. They don't want to lose their job. So what's the point? We need to invoice them. And then if they don't pay, we can litigate. We'll almost always win. We'll almost always win. But does that grant you money? If you went and if you're a creditor, someone that is owed money, and you sued a debtor, someone that owes you money, and you won, does that instantly get money in your pocket? No, it doesn't. There's another step that's involved. That's the meat of our matter. We just needed to spend some time to build up to that point. So today we're going to talk about post-judgment collection specifics. This is probably less familiar to many of you, but this is where the rubber hits the road. Because again, we hope people will pay their invoices. If not, we can litigate. Sometimes just because they know they're going to be sued, they'll pay or offer a settlement or offer payment arrangements. But if not, we go through post-judgment collections, which means we have the judgment. Now, how do we collect? So let's get to this, which is our topic today. Okay, so as I mentioned, with breach of contract suits, you go in expecting to win. Should win every time. If you don't win, it could be because of judicial misconduct. You can hold the court responsible. But we'll skip that. Let's just assume that we've won the case. Person didn't pay as they promised, which is what we wanted. So then we sued them. We won the breach of contract suit. Almost always win. So now we need to do post-judgment collections. A little bit art, a little bit science. What does post-judgment collections means? We're going to need to identify the assets that they have and then collect the money that's owed. Well, what does that mean? Okay, so in this case, you're the creditor, the debtor owes you money. And so we've won the lawsuit. Now we need to identify where the money is going to come from if the debtor doesn't pay voluntarily. So again, we could win the lawsuit and then the person could just say, oh, okay, I owe, I'll pay. And that happens, I'd say ballpark 50% of the time. It'll depend a little bit on the mix of debtors you have. But on average, half the people, if they lose, they're like, oh shit, I need to pay. But now we're talking about what to do when they don't voluntarily pay, which could be about half the time. To me, this is fascinating, fascinating. So it's important to understand that the court allows for post-judgment discovery, which means now we can start going and asking legally and ethically a whole bunch of questions to the person that owes money. Well, we also, in addition to asking them questions, which we're going to get to in a minute, we're also going to look at information about them in preparation. So some of the key sites that are used, one is publicdata.com, and you can go to this site if you want. This is where you can get driver's license information, date of birth, addresses, criminal history, vehicle ownership, real estate ownership, lots of information about people, legally and ethically, of course. There's another called Accruent, another database similar to public data, has real estate, driver's license information, UCCs, judgments, criminal history. TLO is one of our favorites. Here we can actually go get people's social security number, their driver's license number, see where their current utilities are with, which of course helps us determine their address, phone numbers, and so forth. If the business owes the debt, if the business is the debtor, each state has a comptroller as well as a secretary of state, which allows for information about the businesses. Okay, so here are some discovery tools. And so when we talk about skip tracing, some of you that have purchased receivables from us, and initially we need to do skip tracing, these are some of the tools that can be used. So in other words, it's understanding more about the debtor as we prepare for either suit and or post-judgment collections. So now let's get to this one. This is the hidden gem right here. This one might floor you. So again, you must look at this in the spirit of the conversation. This is a technique to use when people owe money, they've been invoiced, they didn't pay. We said, hey, we're going to sue you if you don't pay. They didn't pay. We sued them and they still didn't pay. And now we're playing hardball at this point, legally and ethically. So let's talk about the teeth that can occur when someone has been sued, they lost, and they haven't paid. So we want to use subpoenas and request for information. As highlighted in yellow and as in red, if they don't comply, they will go to jail. So you might say, hey, I didn't think you could go to jail for owing money. I believe that to be true. However, if you don't comply with the laws for post-judgment discovery, contempt of court can be filed and you'll go to jail, typically for 3 days. Then you got to go provide the information that's requested. So think about this. This is extraordinarily effective in getting people to pay that would otherwise flip you the bird and say, sue me, I don't care, or I don't have anything, or you're not going to get anything. That is a very infantile, childish approach, because the pain of going through post-judgment discovery will probably break them. So if they don't comply, we file with the court, contempt of court, literally, they go to jail, typically 3 days. That sucks, right? Because they're going to be extradited to Wood County, Texas. So now they're on a prison bus from Seattle or Miami. They spend 3 days in jail, which isn't a real long time, but it kind of sucks. Okay, so what we do to gather information, because what's the goal here? Someone owes the money. They didn't pay the invoice. We litigated. We won. They still don't want to pay. They're playing hardball. So then we can use oral depositions as well as other discovery tools. But the oral deposition is crazy effective. Crazy effective. So this is where we subpoena, which means a legal demand. You've got to show up for an in-person 1 to 3 days of questioning. So come on in. We're going to spend 1, 2, or 3 days, and we've got a boatload of questions. But oh, by the way, when you come, you need to bring 55. We provide a list, and I can share this with you if anyone wants to see. List 55 items long that they need to bring. Oh, you didn't bring it? Then you're not complying with the court order. You're in contempt. So what would be on this list? Because it's devastating to provide, right? It's much easier for these people to pay the bills that they promised to pay than to go through this. And this isn't meant to be mean, but they owe you money, or they owe your client money, right? The client has bought receivables. The client, and we can help them with this, has invoiced the debtor. The debtor didn't pay. We litigated them. The debtor still didn't pay. So there, now let's talk about what happens to the debtor. So what are some examples? And this is just a short list. I didn't want to, it would take, 2 pages just to list all 55 requests. But income, for example, income tax returns for the past 4 years. We need a listing of all of your personal property, right? Because you owe money, in this case, not you personally, but we're just role playing. So we're talking to the debtor. The debtor owes money to the creditor. I need to know everything you own. I need a list of everything you own. Oh, I don't want to provide that. That is contempt of court. No, you must provide it. I need a list of every article of clothing you have. Please list the size and the age. I need to know, do you have any small appliances, toasters, microwaves? It's got to be on the list. It's got to be on the list. I don't want to tell you what type of toaster I have. Contempt. Do you have any intimacy toys? Anything that's freaking embarrassing? Put it on the list if you own it. I don't want to do that. You're in contempt. Right? So much easier for them to pay their bill than to go through this. Do they own any real estate? What type of subscriptions? Do they subscribe to Netflix or or other online subscriptions? They have any adult website subscriptions? Oh, I don't want to tell you that. You're in contempt. Go to jail, spend 3 days, and then answer the question. Right? So what you're doing is really tightening the screws on the debtors. Are we being mean? Absolutely not. These are people that owe money, and how many chances have we asked? We invoice them, please pay. The creditor, no. All right, we're going to sue you if you don't pay. No, I'm not going to pay. Then we're going to win the lawsuit, and now we're going to gather exhaustive, personal, and compromising, sometimes compromising information, so we know what we can go collect from you, because we may like that toaster. We may take your toaster. Okay, real estate, subscriptions. We need your monthly budget. What are you spending money on? Do you buy any alcohol or drugs, pornography? Do you hire prostitutes? Well, I don't want to tell you that. Contempt. We need a detailed budget. And we want to substantiate that with your bank statements and other financial records. If they own businesses, that's great, because obviously we can garnish those or take possession. You could literally take ownership of the business, or we could have a receiver put in place. So again, we've got the creditor that's owed money, the debtor owes the money, the debtor owns a small business. Well, we could either take that small business as partial payment, their plumbing service or whatever it is they do, or we could require the court, or motion for the court, to put a receiver in, which means that that debtor no longer runs their business. We have an independent third party to run their business. How much cash do you have on hand, bank statements, and much more. So in summary, while transferring receivables is a remarkably effective and legal way to improve the credibility of a client so they can qualify for funding, we don't want to just transfer the receivables. We want to collect the receivables. We want the client to have the money coming in. How does that happen? Start with an invoice. Some people will pay as agreed. If not, let them know we're going to sue. Hopefully they'll pay rather than being sued. If not, we go through the court system, fair trial, breach the contract, they owe it. Now, do you want to pay? Yes, great. If not, then we're going to go to post-judgment collection specifics, as we've talked about. So money, if it's owed to the client, it can be collected. And so some people say, well, I have a minimum wage job, so you couldn't get anything out of me. Well, the laws do vary state to state, but in general, low income may make the repayment take longer. But sure, you could have someone with minimum wage or 1099 income and still get blood out of that turnip. All right, so who has questions on today's topic? The purpose of sharing this with you is so we understand that, number one, we can help clients become credible for funding by adding collateral through either of these two options. And then not only do we want to add assets to help them go to funding, we also want to help them collect the receivables to turn that into cash. And the way that works is we would first want to invoice, just a nice friendly, hey, you owe, you haven't paid, please pay. Great, hopefully they'll pay. If not, then we can litigate, and then we go to post-judgment collection process, which is very aggressive. Who has questions, comments, concerns on the collection process as it relates to receivables? All right, Timothy has the first question. So he's asking, how does this kind of kick in for clients? Well, the first thing that we're going to do when a client enrolls is get their financials and look at their balance sheet. And we then can determine, do they have a collateral shortfall? Hopefully not. Hopefully they have enough collateral on their financials. But if not, we have two solutions to add assets. And so then these assets are added, fixes the collateral shortfall problem, Timothy, and then we help the client collect this money from the people that are owed. All right, so who else has questions on the concept of receivables or collections? Because it comes back to the core of what you and I do. What you and I do is we help small businesses become credible enough on paper to be able to qualify for funding. And that's typically built around the 3 C's: credit, collateral, and capacity. Today, we're not talking about 2 of the 3 C's, but we took a deep dive into one of the 3 C's, collateral. How do we resolve that? We legally transfer receivables over. So now their financials are strong enough. We've resolved the problem. There's no longer a collateral shortfall. That happens either through quick cash or the collateral support program. Legal, ethical, effective. Then we want to help the client collect the receivables. And today's message was to help you better understand the steps that typically are followed. Now, we could have a client that buys the receivables and says, oh, no, I don't want to litigate against these people. Well, then that's okay. I mean, if you don't want to do that, you can find another way to ask them to pay, or not ask them to pay at all. I mean, that's up to you. All right, so let's see. We've got a question from Deborah. And good morning, Deborah. And Deborah asks, when do these become assets? Well, so typically within 24 hours, so let's just say next business day, from the time that a client enrolls in quick cash or the collateral support program, we'll get the documentation put together, transfer title, transfer the ownership from us to the client for either $10,000 or $100,000, depending upon which portfolio size they want. So I think the answer to your question, Deborah, is typically within 1 business day, we'll get the assets over on their books. So very, very quickly. Could even happen the same day, but just say on average within 24 hours. So that happens immediately. That's an immediate benefit or near immediate benefit. Then we need to visit with the client and say, okay, great. Now you have, let's say they put 100,000 of receivables on their financials, on their balance sheet. Okay, client, what do you want to do? Do you want help in collecting that money? Because these are real receivables. And if so, we probably will help them litigate, and we almost always win. And if not, we're going to look to see why, because usually the system has failed us if we don't win. And then we're going to go to post-judgment collections. Any other questions that anyone has on the process? Of course, you know how to contact us. Again, today, a bit more of an advanced strategy. Just wanted to share with each of you how we help clients convert receivables into cash. The typical question we'll get was, how long does this take? Well, again, we got to go back and break it down. Well, the invoice can go to the client immediately, to the debtor, I'm sorry, the creditor, in this case, the client, could invoice the debtor, the person that owes money, and they might pay right away. I mean, these are legitimate, real debts. So it could be that they receive payment in just a couple days. If they don't pay, then we can go into litigation. Sometimes, as I mentioned before, the threat of litigation will motivate some people to pay, but for others, it won't. And then we'll litigate, and then we go into post-judgment collections. And here's where it just becomes really uncomfortable for the person that owes the money. If you owe the money, why in the world wouldn't you at least get on a payment plan rather than going through this painful process, which is legal? And if they try to do the ostrich in the sand, oh, I don't care, I'm not going to do this, they're going to go to jail. It's called contempt of court, because once you've won that lawsuit and you have that judgment, judgment is misspelled there, by the way, there's no E in judgment, but once you have a judgment, then you have the power to collect, demand that the person that owes the money provide you this information, so we can go garnish their bank accounts, or garnish their paychecks, or take their toasters. So again, sounds ugly, but this is all about people that aren't paying their money, paying their bills, right? These are people that were asked to please pay your invoice. Oh, I don't owe it. Okay, well, let me send you a copy of the contract called the media to show you. Well, I don't want to pay it. Well, that's a breach then. Let's go get in front of the court, and you can explain to the court why you don't feel like you have to pay it. But the court constitutionally has to follow the words on the agreement. People can make all kinds of emotional pleas. It doesn't matter. Contracts have to be followed according to the United States Supreme Court by what's on the piece of paper, not by he said, she said, not by external factors. That's why breach of contract cases are shut and dry. You should win almost 100%. So with that, then we need to get more aggressive in collecting the money if they don't offer to pay once they've lost. All right, so now you know a little bit more about how we can transfer receivables to clients and how we can help them collect them. Let us know if you have any questions, concerns, thoughts, and we'll see you back tomorrow morning. Have a great day. Bye-bye.